Hi everybody, we're back. So this is mandatory mediation. We are on slide 12 and this is part 2. Okay, so we last left off that arbitrated disputes are usually resolved more quickly than litigated ones. An arbitrated dispute can be resolved in a matter of months, whereas with court it can drag on for a while. So lengthy trials may take an inordinate amount of time to get before a judge because of institutional delay. In the court, dates for interlocutory motions and event trials, although fixed, may not proceed due to a variety of reasons. In arbitration, fixed dates tend to proceed on schedule. Reducing arbitration costs may be achieved by eliminating or limiting certain procedures common to the litigation process. For example, limiting examinations for discovery, including the motions that arise therefrom, and will have a significant impact on the cost, or of course, this is not without a potential negative. These expenses are particularly onerous in lengthy proceedings. Limiting procedures will reduce costs significantly in many arbitrations. A timely resolution by a party selected tribunal familiar with the case from its inception is also a potential cost saver. So the average person, just to let you know, can be an arbitrator. And sometimes you want people in a specific industry that could act as what they call, the acronym is SME or SMEs, which is an acronym for subject matter experts. So the average person, let's say it was an engineering file, if it's a civil or a mechanical engineering file, you might want an arbitrator with that background so they are subject matter experts and are familiar with the area. So, okay. So that's when it says, you might want a tribunal that's familiar, and that's what I go back to earlier that I said, where you can have a panel of 3, and have 2 other arbitrators that represent the parties. Now, again, that doesn't do anything to save costs. That'll probably increase your costs. Okay, so litigation need not always be resolved by way of an action in a trial. Proceedings by way of application under Rule 14 of the Rules of Civil Procedure, for example, where there are no material facts in dispute, is very efficient. One should consider including only matters that are not properly determinable by way of application, drafting an arbitration agreement. So I don't know, I'm going to go back to the Hacker Star. I don't know if you remember that at one point they agreed on several of the terms of what their agreement was going to be, but then they said, why don't we then hire an arbitrator to settle the last issue that Alan Hacker and Stanley Starr couldn't address. So they had settled most of their issues, but just couldn't agree on those one terms. Let's go to arbitration. It's quick, it's quiet, it's efficient, it's done. Nobody has to know. And so when you're doing something like that, where you're bringing in many different styles of process, it's simply called process design. So in this case, their process design was litigation, it was negotiation, and arbitration with no mediation at all. So that's what that whole film was demonstrating, this concept called process design, which is interesting. Okay, so arbitration, again, is often faster and less expensive. We can dispute that because sometimes it is not. Impacts as a primary function of discovery is to learn the other side's case, thus eliminating or limiting discovery may make it more expensive and difficult to prepare for the arbitration hearing. Proper drafting combined with the absence of institutional delay make arbitration the friend of those who seek a speedy resolution, and those who make their motto, justice delayed is justice denied. Generally speaking, arbitration is not the route for those who would rather see a file collect dust on a shelf before any resolution is reached. Special expertise, like I said, choice and continuity. I don't want to know what the law is. I want to know who the judge is. The parties cannot control the outcome, but they choose their tribunal. Parties to an arbitration agreement thus have far more control than in litigation, where the judges are, for the most part, arbitrarily assigned and may not have the expertise in the subject matter. We were just talking about hiring a SME as subject matter expert. Parties will often deal with several masters and judges over the course of a dispute. In arbitration, the tribunal will determine all matters and be well versed in the case. Arbitration agreements without appointment provisions usually end up in court, where the parties cannot agree on their own. A provision should be inserted that provides for a crystal clear appointment process, both with respect to the identity of the arbitrator and the time frame so selecting. And again, that goes back to creation of the arbitration agreement. A provision, process, not to mention greater time and expense. If an agreement to arbitrate is made, the provision governing the arbitration, including the appointment of an arbitrator or the process for appointing one, should be expressly set out. A well-drafted arbitration agreement, will provide for an appointment of a tribunal with the requisite skills to resolve the matter. Again, that subject matter expert piece. The tribunal might be populated by experts in the relevant field or former members of the judiciary or council of high repute. A specialized tribunal familiar with the issue saves time and expenses in resolving disputes. Of course, for some disputes, the courts will be the best forum. For example, litigation may be preferred to determine conflicts that are based on the interpretation of statutes and law. In addition, arbitration may be superior in situations where mandatory or prohibitive orders may be required, not because arbitrators are not or cannot be so empowered, but because the courts may possess greater expertise. Finally, disputes where one party is expected to be difficult to govern might be better served by way of a civil action. Advantages of arbitration. Parties can select the arbitrator, can be based on being a SME. We all know what that is. The proceedings are private and confidential. The rules of procedure can be formal or as informal as the parties and their counsel determine. The cost of the proceedings can often be more easily contained. So that is true. While it could be a little bit more expensive, they can at least determine where the money's going. Due to increased control of the process, there can be a greater opportunity for settlement. In that way, it kind of makes it more collaborative by nature. And arbitral awards are binding under the Commercial Arbitration Act. So disadvantages of arbitration. The success of arbitration is largely dependent on the experience of the arbitrators. Arbitral awards are not of legal precedential value. Recourse against any award is very limited. May not suit disputes involving matters of public law such as constitutional issues. Time and cost can be significantly affected by a lack of cooperation of the parties or poor process design, or by the lack of availability of the arbitrators. So that, believe it or not, was slide 12. So let's move on to slide 13. So this is what slide 13 looks like, types of arbitration. So the process has certain main variations. It can be binding or not binding. By arbitration agreement or contractual clause, so it could be in the contract. So if you look at the fine print in contracts, I know that I had false eyelashes put on a couple of years ago, and a clause in it, because I read the fine print, was subject to, if there's any dispute, it's subject to the American Arbitration Agreement. So or it could be part of a contract, right? So by statute, where it's compulsory, by single arbiter or panel. We're moving on to slide 14. Parties can choose an arbitrator with experience relevant to the substance of their dispute. In binding arbitration, the parties agree to waive their right to go to court for a judicial decision. Kind of makes sense. In non-binding arbitration, the parties have the discretion to abide by the arbitrator's decision, and this is the discretion. Advantages of arbitration. We have gone through quite a bit. Okay, and I'm going to go through them. I guess there's more. Relatively quick and inexpensive. That's kind of questionable. Parties agree to arbitration. No one is dragged into court. Process is user-friendly, chosen by parties, and is relatively private, usually involving only the interested parties and relevant witnesses if necessary. Parties can select the arbitrator. Page 16, disadvantages of arbitration. So the success of arbitration is largely dependent on the experience of the arbitrators. So maybe somebody more junior starting out would want to be on a larger panel where they can observe, still of course they still have input, and their input is important, but they are probably best advised not to be the lead arbitrator right off the bat. Okay, so disadvantages. Arbitral awards are not of legal precedential value. The recourse against an award is very limited. May not suit disputes involving matters of public law such as constitutional issues. And time and cost can be significantly affected by a lack of cooperation by the parties, or poor process design, or by lack of availability of an arbitrator. So again, when we talk about the cost can be significantly affected by a lack of cooperation of the parties, so we're clearly looking at somebody that's not collaborative, or poor process design. That's all in the arbitration agreement. In mediation, it's a little bit different because our agreements are pretty standard. They don't waver that much. Your role, confidentiality, rules of how the process is going to go, breaks, all that kind of stuff, but not to the specifics of the arbitration agreement. They're very different. So on page 17, we're going to look at the arbitration in Ontario. This is slide 17, and yours looks like this. Okay. So in Ontario, all arbitrations are subject to the Arbitration Act. I'm just getting a little, okay. The Arbitration Act, as amended, unless the application of the statute is excluded in whole or in part by the agreement of the parties, or the statute which authorizes a particular arbitration. It sets out both default and mandatory procedures for the conduct in arbitration. Most labor arbitrations are specifically regulated by a particular statute, and the Act does not define arbitration. Very interesting. So, okay. And I'm just going to read a couple of paragraphs and we'll wrap up this particular class. So pursuant to the Act, an arbitrator shall be independent of the parties and act impartially. The Act further provides that subject to a contrary agreement, an arbitral tribunal shall decide a dispute in accordance with the law, including equity, and may order specific performance injunctions and other equitable remedies, may determine any question of the law that arises during the arbitration, or may ask the court by way of application to determine it. So a party may seek judicial determination of a question of law if all the parties to the arbitration consent. The ruling may be appealed to the Court of Appeal with leave. The arbitration agreement and the Act will determine the types of awards that are granted. Under the Act, the tribunal may make interim orders and final awards. An award binds the parties subject to being set aside or varied. Parties may empower the tribunal to determine matters under specified legal or other parameters. And for example, a tribunal might be directed to determine the dispute on the basis of what it deems just, even though this may not accord with the law or the winner-take-all nature of most court orders. A tribunal should arrive at its award based on the evidence before it. Subject to the arbitration agreement, the formal rules of evidence are not as rigid in arbitration as they are in a civil litigation matter. An arbitrator has the power to award the cost of the arbitration set out the process for awarding the costs, the provision of the acts apply. And that is that. Okay, so thank you very much. That is the class content for week 12. And I will get you information on that Scott v. Avery clause. And okay, stay well. If you have any questions at all, as I said, email me anytime. Send an email, my personal email, whatever works for you. Thank you very much. Have a great day.